So we have a major new development in the Duncan versus Bonta California magazine ban case that is currently sitting in front of the Supreme Court and is seeking their review. The plaintiffs in this case just filed a new supplemental brief informing the Supreme Court about that recent Benson ruling striking down Washington, D.C.'s ban on magazines. And the core message of this filing is very simple. The Supreme Court no longer needs to wait on anything else to develop, because the lower courts are now openly split on whether magazine bans violate the Second Amendment. So in this video, we're going to break down the major arguments that the plaintiffs make in this new supplemental brief and why this dramatically increases the chances that the Supreme Court will take review of the Duncan case. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. You can also click the like button. That just tells the algorithm that you appreciate this content, and so it shares it to more people. Now, as I mentioned in the intro, we have a huge update in the California magazine ban challenge that is currently seeking Supreme Court review. Now, first, quickly, I want to recap where Duncan stands and how this all arose. Now, this case challenges California's ban on magazines that hold more than 10 rounds. The Ninth Circuit reviewed this sitting en banc, but ultimately they upheld this California ban. And in doing so, the Ninth Circuit adopted several controversial conclusions going against the Second Amendment. They stated that these magazines that hold more than 10 rounds are not protected arms, that the common use test does not control on these types of cases, and that states may prohibit these types of magazines even if they are widely owned. Now, that decision is currently sitting in front of the Supreme Court. A writ of cert has been sought, and this Duncan case has been relisted multiple times for Supreme Court conference. Now, here is the big development in this Duncan case. As you may recall, back on March 5th, the D.C. Court of Appeals issued its ruling in a case called Benson versus the United States. That court struck down Washington, D.C.'s ban on magazines also holding more than 10 rounds. And now the plaintiffs in the Duncan case have filed a supplemental brief telling the Supreme Court that Benson changes everything. Their argument is that the Supreme Court no longer has any reason to delay resolving this issue, because now there is a clear conflict between appellate courts, differing opinions on the Second Amendment and magazine protections, and that means the Supreme Court needs to step in. Now, the first major point of the supplemental brief is that Benson creates a direct split of authority. According to the filing, the D.C. Court of Appeals struck down a magazine ban, while the Ninth Circuit upheld California's ban in Duncan, which are very similar. The brief says that Benson explicitly parted ways with the Ninth Circuit's reasoning, and that's exactly the type of conflict that the Supreme Court typically resolves. Remember, in the Benson case that we just got, the court there, the D.C. Court of Appeals, was hypercritical of what the Ninth Circuit said in Duncan, and they directly pointed fingers at it and said that they got that analysis wrong. And again, that creates a split between what the Ninth Circuit said and what now the D.C. Court of Appeals said. The plaintiffs also point out that California, in their original response to Duncan seeking Supreme Court review, said that the Supreme Court didn't need to take Duncan, that they should simply wait for lower court conflict and punt this down the road. But now the plaintiffs argue that the wait that California requested, and the reason why they said the Supreme Court should punt this case, is no longer valid. To wait for lower court conflict, makes no more sense, because now there is a conflict, and so there's no need any longer to say that we need to wait for a split. The second major argument focuses on a key issue from the Ninth Circuit ruling. The Ninth Circuit ruled that these magazines are not arms protected by the Second Amendment, but the Benson court completely rejected that idea. Instead, the D.C. court held that magazines of all capacities are arms because they directly facilitate armed self-defense. The supplemental brief here submitted to the Supreme Court highlights that this is a direct legal conflict that needs to be resolved, because the entire Ninth Circuit ruling in Duncan rested on the conclusion that magazines are merely accessories, but the Benson court said the opposite. Another major dispute involves the common use test from Heller and Bruin. Now, the Ninth Circuit minimized the importance of ownership statistics, and they said that these magazines are not protected even if millions exist, and even if millions of people own these, possess these, and use these. But Benson relied heavily on those ownership numbers. The DC court actually concluded that magazines holding more than 10 rounds are not just common, they are ubiquitous. And under Heller, arms that are commonly possessed by law-abiding citizens cannot be just outright categorically banned. The supplemental brief says that this is another fundamental disagreement between the courts that the Supreme Court needs to resolve by granting Duncan. Finally, the brief also argues that Benson exposes a deep disagreement over how courts should apply the Bruin historical test. According to the filing, the DC Court criticized the Ninth Circuit for effectively applying the interest balancing approach, which the Supreme Court actually expressly rejected in their Bruin ruling. Instead, in the Benson case, the court there held that there is no historical tradition of banning arms in common use, which again directly conflicts with what the Ninth Circuit said in Duncan, where in Duncan, the Ninth Circuit tried to use an interest balancing approach. So why does this matter? Well, the key message of this supplemental brief is that the Supreme Court now has the perfect opportunity to resolve this conflict. This case has reached final judgment in the Ninth Circuit, and there is now a clear conflict among the courts. And the stakes are extremely high, especially in this case, because without Supreme Court review, millions of law-abiding gun owners could be turned into criminals by simply possessing magazines that they legally, had acquired or possessed. And especially, I want to note for California, in this specific Duncan case, gun owners in California are in a unique position with this issue because of the Freedom Week period where millions of these magazines were purchased during Freedom Week. And then also you have the prior grandfathered magazines that people possess. And if Duncan is rejected and the Ninth Circuit ruling stands, well then all of us in California that have magazines like this would be exposed to criminal penalties. So this supplemental brief argues that the Supreme Court with this new conflict needs to step in and resolve this issue. Now also, this supplemental filing is very important procedurally. It signals to the Supreme Court that something significant has changed since the petition was originally filed and potentially since they considered it last. And when a new conflict arises while a cert petition is pending, the court often takes that into account when deciding whether they want to grant review. So in other words, this brief essentially tells the justices that the exact condition you were waiting for, which is a different ruling on this very issue, has now arrived, and because of that, you should grant review. And again, this doesn't just affect Duncan and people in California. There are several other magazine ban challenges currently moving through the courts. You have cases like the Third Circuit case, the NJRPC case dealing with New Jersey's magazine ban, the Seventh Circuit Illinois PICA case dealing with magazine bans as well. And there are other, jurisdictions and cases that are also, addressing this type of magazine ban issue. So if the Supreme Court grants review in Duncan, it could finally resolve the national fight over magazine bans, and we could finally get an answer of whether, under the Second Amendment, these types of magazines can just be outright banned and restricted. So that's the latest development in the Duncan versus Bonta California magazine ban case that is currently seeking Supreme Court review. The plaintiffs have now filed a supplemental brief telling the Supreme Court that the Benson ruling creates a direct split among these courts, and that means that the Supreme Court, has a clear reason to finally take up this case. Now we will wait to see whether the Supreme Court justices actually agree with that. And as soon as we hear, whether they decide to relist this case or what they decide to do, if they're going to schedule another conference, if they grant review or anything like that, I will let you know straight away. But if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of two-way content, and so it shares it to more people. But as always, thank you so much for all of your support, but never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.